Welcome to Dorsey and Whitney's Bank Counsel Roundtable webinar on Just What the Doctor Ordered, the Small Business Reorganization Act in the Wake of COVID-19. I'd like to turn the webinar over to Erin Bryan of Counsel and co-chair in Dorsey's Consumer Financial Services Group. Erin?
Thank you. This is Erin Bryan, and I'll be co-presenting today with my colleague, Monica Clark. As Rima mentioned, I practice in the firm's Finance and Restructuring Practice Group. I advise clients in the financial services industry on bankruptcy, default, regulatory, and compliance issues. Monica Clark is a partner in Dorsey's Finance and Restructuring Group and is a co-chair of the Bankruptcy Practice Group. She represents financial institutions, equipment lenders, landlords, and other secured and unsecured creditors in bankruptcy cases and insolvency proceedings. With so much of the workforce working in remote settings, including us, Monica and I are calling in from different locations. There is a chance that the sound quality will vary, but we will do our best to keep it uniform. I want to remind you that today's webinar is 60 minutes. If you are looking for the materials and attendance sheets, they are available for download from Dorsey's webinar reminder sent from events@dorsey.com. Please don't forget to complete the attendance sheets and return to attendance@dorsey.com. We will not be doing Q&A today. Attendees may either contact us directly or reach out to another trusted Dorsey contact. Monica's and my contact information is included in the materials. We are going to start today by providing some historical background regarding the reorganization of small businesses under Chapter 11 of the Bankruptcy Code, and discuss the reasons that Chapter 11 has been viewed as a poor option for small businesses before this. We will discuss how the new Subchapter 5 is intended to address the aspects of Chapter 11 that previously made it unsuitable for small businesses. We will explain the Subchapter 5 process. And finally, we will provide some thoughts on the future of small business reorganizations and what lenders and trade creditors in particular should be thinking about in light of Subchapter 5. And now I will turn it over to Monica Clark.
Welcome, everyone. Thank you for listening in today. You've got a voice switch here. I want to share some numbers as we get started, just to help frame the discussion. As Erin and I were preparing these materials, I came across an article in the Times, actually from just last week, about small businesses and their ability to utilize the bankruptcy code effectively. The author indicated, based on a US Chamber of Commerce poll, that there are 30 million small businesses in the United States, and projected that as many as 40% of these businesses could close in the next 6 months, just disappear. I believe that that is a very sobering thing to contemplate. The numbers are actually shocking. The prospect of losing almost half of the small businesses that are the backbones of many of our communities is even more sobering. As Erin mentioned, Chapter 11 generally hasn't worked particularly well for these kind of businesses. And it hasn't worked well not only for small businesses, but also for even medium-sized businesses. So why is that the case? As anyone knows who has participated in a bankruptcy case, either voluntarily or otherwise, it's an extremely expensive process for debtors. Not only does a debtor have to pay its own legal fees, but it may have to pay other professional fees, such as the fees of a financial advisor or a creditors committee or a financial advisor for a creditors committee. The list can just go on and on. On top of the expense, the bankruptcy process notoriously is lengthy, which of course contributes to the expense. So it can be a very difficult cycle. Congress became wise to these problems in 2005 as part of the Bankruptcy Abuse Prevention and Consumer Protection Act, which was the most significant and sweeping change to the bankruptcy code since it was enacted in 1978. Small business provisions were added to the bankruptcy code. But even these revisions didn't work particularly well because, among many other things, they required small businesses to do additional reporting. So I promise that we're not going to inundate you with numbers because that's really no fun, but I have a few more numbers that I would like to share in thinking about how the new laws affect small businesses. In 2018, small business Chapter 11 cases accounted for less than 25% of the total Chapter 11 cases that were filed nationwide. So as you can see from the slide, there were about 6,000 Chapter 11 cases filed in 2018, and of those, less than 1,500 were small business cases. So small business cases really represent just a slice of the total filings. In 2019, Congress enacted Subchapter V with some very express goals, including to increase the number of successful reorganizations and thus correspondingly reduce liquidations, to preserve jobs, and by doing all of these things, to increase recoveries for creditors, to maximize recoveries for creditors. Subchapter V is considered a much more ambitious plan than the small business provisions that we just discussed that were added in 2005. From a debtor's perspective, Subchapter V is designed to address the problems that we just identified by simplifying the bankruptcy process, speeding it up, and thus reducing the cost of the bankruptcy process for small business debtors. In 2020, right on the heels of the effectiveness of Subchapter V, the CARES Act increased the debt limit for eligibility for Subchapter V debtors, and we'll talk a little more about that in a minute.
All right, thank you, Monica. The SBRA is codified in a new Subchapter 5 of Chapter 11 of the U.S. Bankruptcy Code. It's commonly referred to as Subchapter 5 or even Sub 5. Subchapter 5 was signed into law in August of 2019 and became effective February 19th of this year. The bill had broad bipartisan support. The House bill was introduced by Republican Representatives Ben Cline of Virginia and Doug Collins of Florida, as well as Democrats Steve Cohen of Tennessee and David Cicilline of Rhode Island. It also had the support of various nonpartisan organizations, such as the American Bankruptcy Institute, the National Bankruptcy Conference, the American College of Bankruptcy, and the National Conference of Bankruptcy Judges. I'd like to share just a few highlights from the congressional report because I think they set the stage for what we're about to discuss next. Small businesses, typically family-owned businesses, startups, and other entrepreneurial ventures, form the backbone of the American economy. For example, it is estimated that companies with 50 to 5,000 employees account for more employment than those with over 5,000. By their very nature, the longevity of these businesses is limited. According to the Small Business Administration Office of Advocacy, approximately 20% of small businesses survive the first year. But by the 5-year mark, only 50% are still in business, and by the 10-year mark, only 1/3 survive. While most Chapter 11 business cases are filed by small business debtors, they are often the least likely to reorganize successfully. And keep in mind that that report was from normal times when we weren't dealing with the sort of economic issues and challenges that we are now. It was with those concerns in mind that Subchapter 5 was enacted. It doesn't repeal the existing small business provisions in the bankruptcy code, but instead it creates an alternative procedure that small business debtors may use to reorganize. Subchapter 5 is available to persons, which include businesses and individuals engaged in commercial or business activity. Single asset real estate debtors are excluded. And a single asset real estate debtor, for those who aren't familiar, is a debtor whose primary business activity is owning a single piece of real estate. However, a debtor whose primary business activity is owning or operating more than one property is eligible for Subchapter 5. Monica?
Thanks, Erin. So Congress initially limited Subchapter 5 relief to small business debtors whose secured and unsecured debts totaled no more than 2.725 million approximately. And that actually is a fairly comparatively small number. In calculating that debt limit, a debtor gets to exclude its contingent debt, its unliquidated debt, and any debt that's owed to affiliates or insiders. So that really excludes quite a swath of debt. It actually eliminates a majority of debt. At least 50% of the debt must arise from commercial or business activities. Now, commercial or business activities aren't defined in the bankruptcy code. So what constitutes a commercial or a business activity will be left up to judicial interpretation. Now, as mentioned, on March 27th of this year, Congress increased the debt limit from 2.7 million to 7.5 million for 1 year as part of the CARES Act. So let's return just a moment to our opening statistic that there are 30 million small businesses in the United States. With the increased debt limit, it has been estimated that as many as 70% of these businesses may now qualify for subchapter relief. And that statistic comes from Brookings. So most small businesses will be able to take advantage of Subchapter 5 if they elect to do so. And one quick kind of interesting fact, it had been originally discussed that the increased debt limit would be 10 million to correspond to the change to the Chapter 12 debt limit, which now is $10 million, and that goes back to the fall as part of the Farmer Relief Act. Erin, if you could switch the slide, please. All right, so on the subject of election, how does a Chapter 11 small business debtor decide to pick Subchapter 5? Well, a small business debtor that files a Chapter 11 case it's not automatically placed into Subchapter 5. The debtor has to elect to proceed under Subchapter 5, and it makes that election simply by checking a box on its bankruptcy petition. There are some interesting issues associated with the timing of an election, and those issues are compounded by the fact that the bankruptcy rules permit a debtor to amend its petition at any time before a case is closed. That seems remarkable, but most debtors that elect Chapter 5, we expect that they'll do so at the time they file their bankruptcy case. Now, we'll touch a little bit on this topic at the end, but recently, debtors with small business Chapter 11 cases that were pending when the Act became effective have sought to redesignate their cases and have been successful in doing it so that they could take advantage of Subchapter 5, sometimes as many as 15 months after they filed their bankruptcy case. Under the bankruptcy rules, the U.S. trustee and creditors and others can object to an election, and they have a rather tight timeline to do so. They have 30 days to object after the meeting of creditors is concluded or after any amendment to the Subchapter 5 debtor's election. And what's interesting here is that if no one objects, the debtor's election stands. It governs. So if you're a creditor and you want to object to a small business election, to a Subchapter 5 election, you need to watch your deadlines carefully.
Thank you. All right, so what documents must a Subchapter 5 debtor file? The Bankruptcy Code contains many traps for the unwary, and Subchapter 5 is no exception to this. Here's just one example. Section 1181 of Subchapter 5 declares Section 1116 of Chapter 11, which is duties of trustee or debtor in possession in small business cases, to be inapplicable to Subchapter 5 cases. But then Section 1187 of Subchapter 5 goes on to incorporate most of Section 1116's requirements by reference, and that includes the filing requirements. As a result, a Subchapter 5 debtor must file, like any other Chapter 11 debtor, its most recent balance sheet, statement of operations, cash flow statement, and federal income tax return. And if those documents have not been prepared or filed, the debtor can instead submit a sworn statement that those documents do not exist. A few notable aspects of Subchapter 5 filings. In many ways, Subchapter 5 is similar to Chapter 12 and Chapter 13 of the Bankruptcy Code. Chapter 13 provides a reorganization mechanism for consumer debtors with regular income, and Chapter 12 provides a reorganization mechanism for family farmers and fishermen. Like Chapter 12 and Chapter 13, Subchapter 5 allows a debtor to repay debts over 3 to 5 years using projected disposable income. We'll talk later about what that means. Administrative expenses may be paid over the plan term rather than at confirmation, like in a traditional Chapter 11 case. This even includes the fees of the debtor's attorney. We will talk later about how that may make the representation of Subchapter 5 debtors less appealing or feasible to some firms. The absolute priority rule doesn't apply, so owners can retain their interest in the debtor without paying senior creditors in full. A plan can be confirmed without the vote of any impaired consenting class, so long as the plan does not discriminate unfairly and is fair and equitable. In Subchapter 5, only the debtor can file a plan, and it must be filed within the first 90 days of the case. However, like other Subchapter V deadlines, the bankruptcy court can extend this deadline if the need for the extension is attributable to circumstances for which the debtor should not justly be held accountable. Subchapter V debtors who request extensions based on pandemic disruption, for example, are likely to receive them. All right, Monica, back to you.
Thanks, Erin. Okay, so Subchapter 5 creates some interesting new roles. We have a new participant in the bankruptcy process since Subchapter 5 provides for the automatic appointment of a standing trustee. Now, Erin and I reached out to some of our bankruptcy friends, one of whom is a standing trustee here in the District of Minnesota, and the other who just confirmed the first Subchapter 5 plan in the country, here again in the District of Minnesota. We thought it would be helpful to get some insights on what the standing trustee's role is and how they function in Subchapter 5 cases. So the standing trustee primarily is tasked with facilitating, and I'm reading from the Bankruptcy Code, the development of a consensual plan of reorganization. So that's essentially the job description for the standing trustee. The standing trustee has been described as being kind of like a mediator. And according to the standing trustee with whom Erin and I spoke, that description really isn't too far off. The standing trustee receives plan payments and then makes distributions to creditors. The standing trustee's duties can also include appearing at the 60-day status conference that we'll talk about in just a bit, and all other major hearings. The standing trustee will review and object to proofs of claim, will make a final report and file a final account. The standing trustee can also make adequate protection payments to creditors if authorized to do that by the court. The standing trustee that we spoke with told us that she had objected to a creditor's motion to lift the automatic stay that was filed early on in the case. Standing trustee also would be expected to participate in the initial debtor interview with the U.S. trustee, the debtor, and debtor's counsel, as well as the meeting of creditors. So that just gives you a general idea of some of the tasks that a standing trustee might be expected to participate in. Now, importantly, notwithstanding the fact that a standing trustee is appointed, the debtor retains control of its business and assets, just like a debtor in possession. Now, that being said, a standing trustee can be authorized to operate a debtor's business if ordered to do so by the court. And that kind of a situation might occur in cases of fraud or mismanagement, much like a Chapter 11 trustee would function. Regarding compensation, we understand that the standing trustees are paid at their hourly rates, and they file fee applications just like any other professional, a state professional would do. And in case anyone's interested, there are approximately 250 acting standing trustees nationwide. And here in Minnesota, there are 4 standing trustees, including one of our retired Minnesota bankruptcy judges.
Thanks, Monica. And I did find it really interesting that in Monica's and my home district, the approach that is being taken is to assign cases to the Subchapter 5 trustees based on a variety of factors. So they're able to match them and their expertise to the case. It's pretty interesting. All right, I'm going to talk now about the role of creditors committees. And before I talk about how it's really not a thing in these cases, just for some background for those who are less familiar with the bankruptcy process. One of the key players in a typical Chapter 11 case is the Unsecured Creditors Committee. Section 1102 of the Bankruptcy Code requires that in a Chapter 11 case, the U.S. trustee appoint a committee of unsecured creditors as soon as practicable after the entry of the order for relief. The purpose of the committee is to increase creditor participation in Chapter 11 cases. The Bankruptcy Code provides that ordinarily, in a Chapter 11 case, the committee consists of persons who are willing to serve and who hold the 7 largest unsecured claims of the kinds represented on the committee. The committee may consult with the debtor, investigate the debtor and its business operations, and participate in the formulation of a plan of reorganization. However, in Subchapter 5 cases, there are generally no unsecured creditors committees. The bankruptcy court can order the appointment of a creditors committee, but only for cause. So this is likely going to be very unusual in these cases. This is beneficial for debtors because it reduces administrative costs. As Monica mentioned earlier, those costs are borne by the debtor in these cases, and so the elimination of this is a cost-saving mechanism. This also reflects the drafter's perception that unsecured creditors may be less involved in small Chapter 11 cases because unsecured creditors in small cases may feel that the size of their claim is not significant enough to justify the time and cost of active participation. However, the elimination of the committee in Subchapter 5 cases also greatly reduces the availability of what is arguably the most powerful tool in the unsecured creditors toolbox.
As we've noted, the Subchapter 5 reorganization process is designed to be very brisk. And in keeping with this brisk pace, the bankruptcy court must conduct a status conference no later than 60 days after the bankruptcy case is filed. Now, the Subchapter 5 debtor is required to file a pre-status conference report 14 days before the status conference takes place. And that report must describe the debtor's previous and ongoing efforts to achieve a consensual plan of reorganization, because remember, that's the goal of the Subchapter 5 process. And because of this timeline, it really means the debtor needs to get going on negotiating with its creditors and other constituencies and trying to achieve this consensus almost immediately after it files its bankruptcy case. As noted earlier, the Subchapter 5 debtor must file a plan no later than 90 days after it files its bankruptcy case. The 90-day time period is the very same time period that applies to debtors in Chapter 12 cases. Now, these deadlines may be extended if the bankruptcy court finds that an extension is warranted because of circumstances which are beyond the debtor's control. I'm paraphrasing just a bit here from the actual statutory language. And importantly, Subchapter 5 does not limit the number of extensions that can be requested or the length of extensions that can be requested. So I'm going to draw again on this comparison between Chapter 12 and Subchapter 5. In Chapter 12 cases, as many of you may know, extensions to file plans really are regularly granted, and they're expected to be granted in Subchapter 5 cases too. Especially now in this economic environment, a debtor whose business has been sidelined by the pandemic is not going to be able to put together projections or satisfy any of the other plan filing requirements that we're going to talk about. So creditors should expect extensions of these deadlines to be regularly granted. Next slide, please, Erin. Subchapter 5 eliminates some of the time-consuming and expensive activities in which debtors have to participate. In Subchapter 5 cases, a separate disclosure statement is not required. And this reduces cost and streamlines the process for debtors because it's no longer necessary for a debtor to prepare a disclosure statement and go through the process of getting it approved before proceeding to plan confirmation. That is a big cost saver, it's a big time saver. That being said, the plan must include a brief history of the debtor's business operations, a liquidation analysis, and projections concerning the debtor's ability to make plan payments. And this is information that is traditionally contained in disclosure statements anyway. As Erin mentioned, administrative claims may be paid over the duration of the plan rather than being paid on the effective date, as most of us are familiar with in Chapter 11 cases. And these claims even include the attorney's fees of the debtor. So imagine how well that would go over with debtor's counsel. We'll talk about that in just a bit. Importantly, creditors may not file competing plans, unlike in traditional Chapter 11 cases, where creditors can file competing plans provided the exclusivity period has expired. Subchapter 5 debtors enjoy the ability to modify their plans at any time before the plan is confirmed, and then even after confirmation, provided the plan hasn't been substantially consummated.
All right. The general confirmation requirements for a Subchapter 5 plan are going to be largely the same as the requirements for other Chapter 11 cases. And I've listed them out here. It includes all of the usual requirements with the exception of 1129A15. For example, the plan must comply with the bankruptcy code and the debtor must have obtained all necessary approvals. Certain expenses must be paid, although as Monica mentioned, administrative expenses are dealt with differently. And the plan must be feasible, among other things. However, there are some major differences when it comes to confirmation of a non-consensual plan. And I'll just point out again while we're on this slide that Subchapter 5 cases are exempt from paying U.S. trustee fees. That's one of the cost-saving mechanisms in this subchapter. Unlike in traditional Chapter 11 cases, the Subchapter 5 debtor does not need an impaired class of creditors to accept the plan in order to get it confirmed. To confirm a plan without all classes consenting, the plan must be fair and equitable as to each class of creditors. Generally speaking, a plan is fair and equitable if all of the debtor's disposable income is applied to plan payments. For a class of secured claims, that means the plan must meet the usual requirements of Section 1129B2A. Although I will point out there are lien stripping rights for Subchapter 5 that we will discuss in a few minutes. And as noted earlier, Subchapter 5 eliminates the absolute priority rule. One result of this is that in some instances, equity holders may retain their interest even if unsecured claims are not being paid in full.
All right, so Erin just mentioned the concept of disposable income, which is a familiar phrase to those of you who have experience with Chapter 13. Now, Erin, you have more experience with Chapter 13 than I do, so feel free to jump in here if I mess things up. But disposable income is defined in Chapter 13, and actually that definition applies to Chapter 11 cases involving individuals as well. Now, Subchapter 5 contains its own definition of disposable income. For purposes of Subchapter 5, disposable income refers to income received by the Subchapter 5 debtor that isn't reasonably needed for the maintenance or support of the debtor or one of the debtor's dependents, needed for domestic support obligations that first become payable after the date of the filing of the case, or the payment of expenditures necessary for the continuation, preservation, or operation of the debtor's business. Now, what does it mean for something to be reasonably necessary or reasonably needed? Well, the Bankruptcy Code is silent on that point, among many others. The Subchapter 5 formulation is far less complicated than the Chapter 13 formulation, which I won't even begin to describe, which suggests to us that most courts will be guided by the Chapter 13 and individual Chapter 11 case law when it comes to figuring out just what this means. What does it mean for something to be reasonably necessary? That case law is highly factual. It varies quite a bit from one jurisdiction to another, and even in the same district from one judge to the next. So I think we really need to stay tuned to see how this issue unfolds. But at the end of the day, disposable income is a very flexible concept, and debtors don't have to give away everything they have in order to satisfy the test.
All right, residential mortgages. As I mentioned a few moments ago, the Subchapter 5 debtor may strip the lien of a creditor whose claim is secured by a mortgage on the debtor's principal residence. For those of you with a lot of consumer bankruptcy experience, this is going to bring back many memories. According to a 2017 Federal Reserve Board report to Congress on the availability of credit to small businesses, in 2014, about 55% of firms received funding from their owners. And small business owners often provide funding for their businesses from their own personal savings, retirement accounts, funds they borrow personally, or, importantly, home equity loans. Subchapter 5 lien stripping can only be done if the new value that the debtor had received in connection with the extension of credit was not used primarily to acquire the real property. So this doesn't apply to first mortgages that a debtor used to acquire a residence. In other words, this will typically apply to HELOCs that a small business owner took out in order to support the business. In addition, the new value must have been actually used primarily in connection with the debtor's small business. Whether or not a debtor does use Subchapter 5 to strip a secured creditor's lien, just the possibility of doing this can give a debtor tremendous leverage in these cases. A secured creditor is not going to want to lose the lien. And so this gives the debtor a way to bring the secured creditor to the negotiating table in order to work out a consensual plan.
All right, so let's talk for just a quick moment about the Subchapter 5 debtor's discharge. If a confirmed plan is consensual, the Subchapter V debtor receives their discharge right away at the time of confirmation. And this is just one of the examples of how Subchapter V incentivizes debtors to propose plans that can be confirmed consensually. If a confirmed plan is not consensual, the Subchapter V debtor receives its discharge after it makes all of its plan payments. Depending on the length of the plan, whether it's 3 years, 4 years, 5 years, the debtor will get its discharge at the end, unless the plan or the court orders otherwise. Similar to Chapter 13 cases, the discharge will not apply to any debts for which the last payment is due after the plan period. So a long-term mortgage would be one example of a debt that would not be discharged. So just when we've depressed everyone on the phone talking about these erosions of creditor rights, we wanted to share some good news. So while almost all of the provisions in the Small Business Reorganization Act apply only to the Subchapter V cases, there are two important exceptions that apply to all preference actions under Section 547 of the Bankruptcy Code. And just a reminder, Section 547 permits a debtor or a trustee to avoid or recapture or claw back payments made to creditors within 90 days before a bankruptcy case is filed, subject, of course, to certain conditions and defenses. Under the Small Business Reorganization Act, plaintiffs now must perform reasonable due diligence and take into account known or reasonably knowable affirmative defenses before they file a preference action. In addition, preference actions that involve less than $25,000 must be filed in the district where the defendant resides, rather than being filed in the district where the bankruptcy case is pending. These are very creditor-friendly changes that we expect to discourage trustees and debtors from pursuing small preference actions, and they should eliminate the rather widespread practice of suing a defendant simply because they are shown in the debtor's books and records as having received a payment in the preference period. So this is all very good news for preference defendants and the attorneys who represent them.
That is really great news, and I'm sure anyone on the phone who's had to deal with the defense of a preference action can appreciate how helpful this will be. There are a few concerning provisions from a creditor's perspective, and we are primarily speaking from a creditor's perspective, although in some cases our firm does represent debtors as well, so I don't want to give the impression that that's all of our work. But from the creditor's perspective, there are a number of concerning provisions here. So first, Subchapter 5 eliminates the requirement that administrative claims be paid at confirmation. Now, why would that matter? Well, this alters the expectation and risk of parties that provide goods and services to the debtor post-confirmation. So that's a substantial change. And instead, administrative claims may be paid over the life of the plan. And of course, there's no guarantee that a plan will be successful, particularly where the term is 3 to 5 years. That's also just a really long time to wait to be paid on these claims. Second, it's not uncommon for a small business owner, as I mentioned earlier, to put their house up as collateral for a business loan. The expanded ability to modify loans secured by a debtor's principal residence may require lenders to scrutinize how the proceeds of loans will be used. Third, unsecured claims can be wiped out fairly easily without equity holders giving up control. This may diminish what little leverage unsecured creditors had in Chapter 11. And add to that the limitations on the appointment of creditors committees could also result in Subchapter 5 cases steamrolling over the interests of unsecured creditors.
And I would just jump in here, Erin, and make one observation. So these are absolutely issues that do sort of raise the eyebrows of creditors. But again, to remind the audience that the goal is to achieve for the Subchapter 5 debtor a consensual plan. So many of the plans that Subchapter 5 debtors will promulgate will in fact pay administrative claims on the effective date, just as creditors would be used to.
That's absolutely right. And as you'll have seen from our discussion so far, so many of the provisions in Subchapter 5 are aimed at streamlining the process, decreasing the potential for litigation within the case, bringing all of the parties to the table to get a resolution worked out quickly. And so, while there are obviously some concerning provisions here, a case moving quickly and efficiently, ultimately that provides some value as well. All right, so Monica?
Yep, thanks, Erin. So I feel like we're kind of coming full circle here, back to the statistics that we mentioned at the start of the presentation. So if those statistics are reliable, especially given our current economic situation, combined with the increase in the debt limits that we mentioned, we expect to see Subchapter 5 cases to increase. Now, there's been a lot of discussion about whether or not we're going to see a flood. I hear we're going to have many, many cases and be overwhelmed. That may not happen. The increase may not be as immediate in this economic environment. Businesses that are not forced to file a bankruptcy case because of creditor action or other factors may be better served to actually sit back and wait a few months to see how and whether their businesses operate in this current climate. We talked to another professional involved in one of these Subchapter 5 cases involving a bar. And we spent some time talking about whether it really was provident to file at this point, or whether it made more sense for a debtor to get 3, 4, 5 months down the line before filing a Subchapter 5 case. Obviously, the debt limit increase is still effective until the end of March next year, so there's some time to make some decisions. But in addition, the ability of a debtor to pay its counsel's fees over the life of the plan creates a very unique risk that many debtors' lawyers, frankly, may not be willing to take on unless they can get a sufficient retainer to mitigate that risk. So there are some very unique structural impediments that we think may drive how many Subchapter 5 cases are filed and how quickly they're filed.
A lot of uncertainty. Well, we also learned that our home district recently confirmed the first Subchapter 5 plan in the country, and that happened in April. We reached out to the home district, Minnesota, which told us that while they are not currently identifying Subchapter 5 cases separately on their statistics page, the ECF system is set up to add a flag to these cases so that the clerk's office is able to identify and track them. So while we don't currently have national statistics on Subchapter V filings, we can expect within the next year or two that we will start to be able to get some data back about how many businesses are choosing this option, particularly while the debt ceiling has been raised due to COVID. And that will give us a better indication going forward of how common of a choice this may be. So far, this clerk's office told us that there has only been one case in that district that was filed as a Subchapter V case, while several others were commenced before the SBRA became effective, but where the debtors later elected Subchapter V treatment. And it sounds like, in general, those elections have not been controversial. The court is now working through some practical issues relating to the notice of substantial consummation, the trustee's report, the discharge of the trustee, and other issues. And other courts are working with them and learning from their progress. In terms of takeaways for our clients and things to be thinking of following this presentation, and of course, we're available to answer questions by email or separately, although we don't have the Q&A directly in this webinar, but just a few things that we wanted to highlight for our lender clients in particular. So to our lender clients, if you have not already done so, we recommend reviewing small business loan underwriting policies and procedures in light of Subchapter V. For example, lenders of secured small business loans may want to at least review, but even reconsider collateral requirements and uses in light of Subchapter V's lien stripping provisions. Monica, what would you recommend for vendors?
Very similarly, Erin, vendors need to be more cautious about providing goods or services generally on credit to distressed small companies, both before and after bankruptcy, since they may not enjoy the same protections that they would have had under a typical Chapter 11 case. We expect to see quite a bit of new case law over the next few months and even frankly longer as courts tackle these new issues that are raised by Subchapter V. So we couldn't resist taking a look at the reported cases, and I'm going to say that we've reviewed them all, but in the interest of full disclosure, there were only 6 of them. So it wasn't a terribly daunting review. And as Erin mentioned, each decision addressed the issue of whether a debtor with a bankruptcy case that was pending at the time of the enactment of the act could amend its petition and proceed under Subchapter V. And no surprise, but each court said yes. And in a couple of these decisions, as I think I mentioned at the start of the presentation, the prior cases, same case, the original case, had been pending for a year or more. There were several cases in which the bankruptcy case had been filed 15 or 16 months before the debtor decided to amend its petition. And the decisions are all very thoughtful. Remember, these are judges that are figuring out how to deal with new law, and each of the decisions signaled a willingness to let debtors really get their footing and to take full advantage of the new law, particularly in the midst of some very difficult circumstances. And it's worth noting that the parties that objected to a debtor's ability to amend its petition were not only creditors, but in some instances, the United States trustee. So I just wanted to share a few parting thoughts as we wrap things up. Before Subchapter 5, the chance that a small business would successfully reorganize under Chapter 11 was frankly very, very remote. We understand the concern of creditors when they think that their rights are being altered or eroded, but to the extent that Subchapter 5 allows businesses that would otherwise need to close their doors and disappear to instead survive and reorganize by repaying their debts over a planned period over time, the benefits can be enormous. And those benefits extend to creditors as well. So if the process works as it is designed to do, fees for everyone will be lower, not just for a debtor's attorney, but also for creditors as well. And standing trustees, again, this new unique player in the bankruptcy system, are likely to be very experienced and very skilled and very well able to cut effectively through some of the deadlock that makes traditional Chapter 11 cases destined to fail. So Subchapter 5 probably will be beneficial to all constituencies in bankruptcy cases. Erin, did you have anything else you wanted to add?
I don't have anything to add since we're coming up on the top of the hour, but thank you. And I really appreciate everyone taking time out of their day to participate in this webinar. It's hard not to be able to see everyone in person that we might ordinarily, but when public health permits, we look forward to seeing all of you again.
Thanks, everyone. Have a great rest of your afternoon.
Thank you.